Hello and welcome to my channel Learning Construction Management with Dr. A.R. Nasir. I am Dr. Abdurrahman Nasir and the slogan for my channel is Construction Management Made Easy. In this video, we will learn about contract and its fundamentals. But before we proceed further, I request you all to please subscribe my channel for keeping me motivated to continue making the educational content for learning construction management. So without further ado, let's get started. In this video, we are going to cover these two topics. First is the definition of a contract, and the second is the fundamentals, or what we say the essentials of a contract. So the first question, what is a contract? When I ask this question among the audience, I usually get the answers like it is a written arrangement between two parties, or it is an agreement between two parties, or an understanding between two parties. Well, these are not incorrect, but kind of incomplete statements, and when we cannot treat these statements as the right definition. Let's learn what actually is a contract. A contract is an agreement between two or more parties that is enforced at law, or you can say is a legally binding document. Let's have a look at some definitions from the known sources. So the Oxford Dictionary defines contract as a written or spoken agreement, especially one concerning the employment, sales, or tenancy that is intended to be enforceable by law. So you can say they have classified this in the form of a written agreement or a spoken or verbal agreement. Yes, contract can be verbal in nature, but it is better if it is in written format. Why? We will talk it in the coming parts. So the second part of the definition tells about that it is concerning about the various trades or businesses. So yes, it actually relates to any of the employment, sales, services, or any tenancy. Another definition, a contract is referred to as an agreement that can be enforced in court. Another definition we have is a contract is an agreement between two or more parties that is legally binding. So we can see that a similar meaning is coming to us, that it is actually an agreement not between two, but it can be between two or more parties that is actually enforceable by law or is a legally binding document. The Business Dictionary says a voluntary, deliberate, and legally binding agreement between two or more competent parties. Contracts are usually written, but they may be spoken in nature or implied and generally have to do with employment, sale, or lease or tenancy. So the similar definitions are coming up. Merriam-Webster Dictionary says a binding agreement between two or more persons or parties, especially the one which is legally enforceable. The Cambridge Dictionary tells us that it is actually a legal document that states and explains a formal agreement between two different people or groups. So from this we can understand that a contract is actually an agreement between two or more parties that is actually legally binding or is enforceable or enforced at law. So what it means that when the two people decides or agree on certain arrangements, if one person or if one party does not perform as per the promise, then the injured party can go to the court of law for the particular compensation of damages. So which in other case might not happen if it is not a contract. So let's move on to the next part of this video, in which we have to tell about the fundamentals, or we can say the essentials of a contract. So every contract must be satisfying these particular fundamentals which we are going to discuss or study right now. And if they all are satisfied, then the particular document can be named as a contract. So in total there are 11 elements that are needed to be in place before a contract can be considered legally binding and enforceable. So let's start with the first one, offer. A contract is formed only when there is a lawful offer by one party to the other party or more parties. The second fundamental is the acceptance. A contract is formed when the offer is lawfully accepted by the other party or parties. Third is the written. So in modern times, it is necessary to have a contract in written format. Yes, verbal contracts can be there, but in this modern era, significance of written contract is huge. The reason is that a written contract usually supersedes all the previous agreements, correspondence, and so on. As they say, what is written is what is meant. Such is the finality of a signed written contract, that a complete understanding of all the contract conditions by both parties is essential. So moving on to the fourth fundamental, we have the intention to create legal relation. In this fundamental, the contract does not exist simply because there is an agreement between two or more parties, but those parties to the agreement must also intend to enter into a legally binding agreement. Moving on to the next fundamental or essential, which is the lawful object. The objective of the contract must not be illegal, which means that the parties cannot agree to perform any particular action or act which is illegal in nature. It cannot be an immoral activity, so the parties cannot agree on the immoral functions to be performed later, and the contract must also not oppose public policy. So the law will not enforce all the contracts. There are some categories of contract to be wary of, because where a contract is illegal in the law of the state or the law of the land, then this affects very much the enforceability of that very contract. Contract absolutely prohibited by the statute or by the state laws will be void, which means they will not be valid whether the parties know of the illegality or not. So a famous phrase in the domain of law is, ignorance is not an excuse. So you must follow all the lawful objects which are there in the statutes or state laws, and the elements must not be illegal or immoral as well. Moving on to the next essential of a contract, we have legal capacity. Not all the people or parties are completely free to enter into a valid contract. Only the parties with the appropriate authority or capacity can make a contract binding and enforceable, which means that one cannot go and have a contract with anyone. There are certain rules and there are certain particular parameters which are to be satisfied under the domain of legal capacity. For example, the minors, they have no legal capacity. The term minor relates to the age of a particular person, which is actually defined in various laws of the land. Somewhere the minors have not acquired the age of 18 years. So in those particular areas or in those particular states, one cannot have a party that is minor in a contract. So in that case, it will not be a valid contract. Similarly, those who are insane and those who are bankrupts, so those who have been declared bankrupts, they can also not form a contract because they do not have a legal capacity to enter into a contract. Moving forward to the next and the very, very important fundamental of a contract, we have the consideration. This is the area in which people tend to get confused that what this actually is all about. So consideration is actually something of a value, something of a monetary value that is exchanged between the parties, because everyone is there for a monetary benefit. If I want my house to be constructed, so I will, in the end, when a contractor will construct my house, I will get something of a monetary value, which is my house. And on the other hand, the contractor will get a monetary value, which is the payment which I will give him once he will proceed with the agreed milestones. So consideration can be something of value, goods or services, though it need not only be money. So I may not be providing the money to the contractor. Instead, I can substitute the money with any of the services, but it has to be agreed between both the parties. So normally consideration is usually evidence in the contract as the payment of money or a transactional aspect in the contract. Moving further, free consent, the offer and the acceptance. So the offer is made by party A, which was accepted by party B, must be freely consented by the parties without any sort of coercion, undue influence, fraud, etc. All parties must agree to the same terms. The law recognizes the existence of a contract if there is a mutual agreement on all the essential terms. Moving forward to the ninth fundamental of the contract, we have the certain and definite. So what it actually means that every contract must be certain and definite in nature. So contract must not be uncertain, vague or indefinite. Where the agreement is vague and meaning cannot be ascertained directly from the contract, then it might not be a contract because it is not following this very fundamental, which is being certain and definite. All parties must agree to the same terms which are expressed in the contract. The next in line, the 10th fundamental of a contract, is the possibility of performance. For a valid contract, it is necessary that it must be capable of being performed. Accessibility of construction site to the contractor by the client is one of the examples. So, if a client does not provide the access of the construction site to the contractor, how will he execute the works? It is another important fundamental that the possibility of performance must be met. The next in line and the last fundamental of the contract is the fulfillment of the legal formalities. There are certain formalities which are required to be fulfilled in order to be the contract satisfying this very fundamental. For example, witnesses of a contract are very vital because they are the one who can verify the contract in times of need when the court of law comes into action. Registration of a contract from any legal authorities like registrar or any other person is also another vital element which needs to be satisfied in order to make those particular contracts enforceable at law and binding in nature. Let's discuss an example. If A says to party B, I will repair your house, and B makes no promise in return, is there an agreement? No, there is no agreement. If B says, okay, I will pay you $10,000, is now an agreement? No. Why? Because it takes two to make an agreement. An agreement involves an exchange of promises or goods. Party A has not yet agreed to accept $10,000 for doing the work. If party A says, I will accept $1,000, there is an agreement on price. But is it a contract? No, it is still not a contract. Unless there is an agreement on all the essential terms which are mentioned in the contract, the law does not recognize the existence of a contract. So is there an agreement on the actual work to be done to repair the house? For example, it might be that A and B know exactly what work is necessary. For example, the repair of a leak in the roof of the house. In that event, the actual work to be performed is agreed and there may be a contract if all the fundamentals or essentials of the contract are satisfied. The contract consists of the following express terms. Party A will repair Party B's house. Party B will pay Party A $10,000 and Party A will accept $10,000. These terms are said to be express terms in the contract because they are the actual words spoken, agreed, and then written on a contract. Here comes my definition of a contract. A contract is an agreement made between two or more parties whereby the legal rights and obligations of the parties are defined, which the law will enforce. That's it. Hope you have liked the video. If yes, then please click the like button. If you have any query regarding the topic, please leave your comment and I will be more than happy to answer you directly. For more learning videos, do subscribe my channel Learning Construction Management with Dr. A.R. Nasir because we believe construction management is made easy. See you soon, take care and goodbye.